Good morning. Today we are going to discuss the third source of law, that is precedent. What is precedent? Precedent is a judge made law. Okay. The first two sources we have already seen, that one is custom and the second was legislation, and the third is precedent. To fill the lacuna in the law made by the legislature, the judges to some extent depend upon their sense of right and wrong. And while applying their sense of right and wrong, what they do, they explain the law to the existing circumstances. So they apply or adopt the law to the changed conditions. And while doing this, as they are logically interpreting, they make a law. Okay. Now that law is to be followed by the lower courts. Means a court is bound by the decision of the superior courts because it is a case law. It is a landmark judgment which is having a binding force. Okay. The base of precedent is what? Like cases should be treated alike. As the cases are having same facts and all, therefore the interpretation should be in the same manner. Therefore the lower judiciary has to follow the judgments given by the superior courts. Okay. Now we will see definition. Bentham. Bentham has defined a judicial precedent is a judge made law. Just one sentence is there. What is judicial precedent? It is a judge made law. Okay. Now what Austin says? Austin says it is a law of a judiciary. What is precedent? It is a law made by the judiciary. Now what Blackstone is telling, by use of precedent, the scale of justice remains balanced and fixed, and the principle which otherwise remain uncertain becomes certain. We will see this. See, if different high courts have given different judgment or different opinion they have on the same subject matter, it is uncertainty in one country. But when that matter goes to the Supreme Court, and when the Supreme Court decides it, it becomes certain. The principle becomes fixed. Therefore, hereafter, the Supreme Court decision must be followed. It is having a binding force because it is a precedent of the Supreme Court. By use of precedent, the scale of justice remains balanced and fixed, and the principle which otherwise remains uncertain becomes certain. It means guidance or authority of past decision for future cases. Okay, that will be called as a precedent. There are two schools of thought relating to precedent. One is declaratory theory and the other is law-making theory. Okay, we'll see the first thought, that is school of thought, that is declaratory theory. What these people believe, judges are mere declarers of the law. Means they are not making laws. They just declare law. The main function of the judge is to discover the principles out of the existing law and decide the cases accordingly. What Koch is telling? Koch is telling judges are only the interpreters of the law. Means they are not the makers of the law. They just interpret. Law is already made by whom? By the parliament. When the matter comes to the court, it comes with facts, isn't it? The case means what? Certain facts. And what the judge has to do? Judge has to apply the existing law to them. He has to just interpret the law. He is not the maker of the law. Justice Blackstone is telling that a judge is sworn to determine not according to his own private judgment, but according to the known laws and customs of the land. Not delegated to pronounce a new law, but to maintain and explain the old one. Means Blackstone is telling that judges are not the makers of the law. They have to just interpret, they have to just declare, they have to just apply that concerned law to the existing circumstances. Okay. Now this theory has been criticized, and what Austin says, no, judges are not mere declarers of the law. When a judge applies his mind, really he is creating certain things. Therefore a judge is the maker of the law. This fiction was previously adopted to guard against unwise innovations and to preserve the element of certainty in the law. In the field of equity, the courts have played a very important role. Judges have not only been active and modifying, rationalizing, but they are explaining the common law rules. They are really creating also certain things. Therefore, Austin says judges are not only going to interpret the law, but also expound new propositions of the law. Okay, as we say, Menka Gandhi versus One of India. Keshavananda Bharati case, and the concepts which the judge has created in it, those are landmark, those are immortal cases. We are going to follow years hereafter. Okay, means for future times we are going to follow these landmark cases. Therefore, Austin said judges are not just interpreters, judges are the makers of the law. Okay, now this was the first theory and its criticism. Its criticism is what? Giving importance to the judges as makers of the law. The second thought is what? Law-making theory. That is, judges are lawmakers. They are making the law. They are not just interpreting the law. They are making the law. Judges make law in the same sense in which the legislators make law. This theory gained momentum in the common law countries because important role was given to whom? To the judiciary in making the law. What Gray says, Gray is going extreme and he is saying judges alone are the makers of the law. Means according to him, the parliament is not making the law. They are making just a statute. They are not making the law in the proper sense. Who makes the law in a proper sense? Those are the judges. President Roosevelt has mentioned that the chief lawmakers in our country may be often are and judges because they are the final seat of the authority. Means the judges are in the final seat of the authority. What they say, that is a law. Means their judgment is a law. These two theories are completely extreme to each other. Law-making theory is saying that judges are only the makers of the law. Declaratory theory is saying that judges are just declarers of the law. They are not the makers of the law. Okay. Now, when we say that judges alone are the makers of the law, this thought is also to be criticized because a judge cannot, you can say, he can make a law, but when a case comes to him, so he will explain only when, he will create only when the facts come before him. Therefore, the legislative power restricted to the facts of the case. A judge can make a law, but only for those facts which come before him. If a matter does not come before him, he cannot make a law on that. Therefore, legislative power of the court is restricted to the facts of the case before him. Okay, authoritative precedent also limit the law-making powers of the judge as he cannot depart from him. You are telling that judges are only the makers of the law. But once the Supreme Court has given a landmark judgment, it will be followed by the lower court. It means the High Court's powers of making a precedent is restricted. So, authoritative precedent limit the law-making power of the judge as he cannot depart from them. Second is legislative power restricted to the facts of the case before the judge. Okay, the judge, you can say the judge makes the law, but he has to follow the law made by the parliament. He cannot go away from the four corners of the section or four corners of that concerned statute. Justice Holmes is telling judges do legislate, but they are confined. They are confined with a statute. A judge cannot say that doctrine of consideration is a bit historical nonsense and I shall not enforce it in my court. No, a judge cannot make a law by his own whim and wish. He is bound by law. The judge cannot, however much he may wish to do so, sweep away from the prevailing rule of law and substitute something else in the place. Okay, means now one theory is telling that judges are just the makers of the law. Other theory is telling that no, judges are just the declarers of the law. Then what is the correct view then? Then we have to bring up midway. Whether judge make law or declare law depend on the nature of the particular legal system. Okay, in common law countries, role of the judges is creative, because in those countries what happens, law is yet to be made, the legal system is yet to be developed. There the judges play a very important role. In countries where law has been codified, the role of judge has been comparatively less creative. Therefore, what is the correct picture? Judicial function lies in the synthesis of both these concepts or both these views. Declaring does not mean mechanically declaring like the parliament, and it means what? Judge is a human being, he applies his mind. Declaring does not mean something mechanical but also involves a creative and intelligent process. Making does not mean that judge make law in the sense of the legislators make the law. he puts the life into the dead words of the statute. We have to consider Parliament makes the law for the future facts, but when a judge is sitting on his dais and he is deciding a case, he is having real facts before him. Therefore, he has to interpret the law in a proper sense by giving meaning to each and every words. Sometimes he has to extend the meaning of the words. Sometimes he has to restrict the meaning of the words. Therefore, really you can say that in certain cases, judge has put his mind and everything to that case and he has given a proper judgment. So what Salmond is telling, both at law and in equity, however, declaratory theory must be totally rejected. If we are to attend any sound analysis, we must admit openly that precedent make a law as well as they declare it. Judges in some aspect really make a law, and in certain cases you can say that judges are just the declarers of the law. In a country where law is being codified properly and all, judge is not having much work to do. He just has to declare. But when the facts and the law, there is a gap between it. That gap, that lacuna must be fulfilled by the judge, must be filled by the judge. Therefore, at that time, he puts his mind and all. He gives a logical interpretation. He puts life into the dead words of statute. Okay. Today, we have just seen a part of precedent. In the next lecture, we are going to continue this topic. Okay. Bye-bye. See you in the next video.